Defendant was convicted of second-degree murder and sentenced to 25 years to life in prison for events occurring on March 31st, 1992 in Brooklyn. The people introduced evidence that the deceased told Carl Grant that he could no longer sell drugs on a particular corner because Carroll and his friends wanted to sell drugs there. Shortly thereafter, Grant returned to the corner with several other persons. Carroll and Grant began to fight, and while they were fighting, defendant pulled a gun from his jacket and fired several shots. Carroll was shot and killed, and 3 others were wounded. According to the prosecution, defendant was the sole gunman. Defendant, however, contended that the eyewitnesses to the shooting had falsely identified him as the shooter. Defendant also argued that there were several shooters involved in the incident and that the decedent had been caught in a crossfire between the rival groups. There is no question that the people disclosed the existence of a ballistics report in their voluntary disclosure form dated October 1st, 1997, and that defendant asked for any ballistics report in his omnibus motion dated October 30th, 1997, and returnable January 8th, 1998. In addition, by demand to produce and by facsimile both documents dated October 30th, 1997, the defense attorney specifically requested ballistics reports. In a reply to the omnibus motion dated January 7th, 1998, the prosecutor stated that the ballistics report would be produced prior to the opening statement. Nevertheless, defense counsel did not seek a court order for production of the ballistics report. Although defendant did not notice or make an opening statement, he did cross-examine the medical examiner and a public officer who investigated the crime scene before he contended that he had not received the ballistics report. The people turned over to him a ballistics report which showed that 20 shells of the same caliber were discovered at the scene of the crime and came from one gun. Defense counsel urged the trial court to preclude the evidence, arguing that the prosecutor violated Criminal Procedure Law Section 240.20 by allegedly filing or failing to disclose the ballistics report before the commencement of trial, despite the prosecution's contention to the contrary. Defense counsel argued that he was prejudiced by the delay in receiving the ballistics report. In opposition, the prosecutor argued that he had timely disclosed the ballistics report when he returned over 2 large packets of material of approximately 500 pages prior to trial. The items turned over were not identified on the record. The people agreed, notwithstanding the disputed pretrial disclosure, to provide defense counsel with a copy of the report upon the receipt of the document. Defense counsel again moved to have the evidence precluded, claiming that the document report had never been disclosed and that if counsel had known of its contents, he never would have questioned the witnesses about the number of responses used in the report. That was 128.